I'd just like to go over the basics of the appeal procedure to get to the Constitutional Court. I've mentioned it lightly before, but I'll just put it in plain now. An action or an application is brought in the High Court. The matter is finally adjudicated, and one party is aggrieved by the outcome. That party can then appeal the matter, either to a full bench of the same High Court, that's with 3 judges sitting, or if a petition for leave to appeal fails in the High Court, you would then petition the Supreme Court of Appeal for an appeal. The matter will then be heard in the Supreme Court of Appeal and decided. Or the Supreme Court of Appeal will say that they do not believe that there is a novel question of law, nor are there reasonable prospects of success. The matter is then able to be moved to the Constitutional Court. There is an application for leave to appeal, as well as an appeal. These, unlike the SCA or the High Court, these are done in two. In the Constitutional Court, this is done in one full application that both applies for leave to appeal and argues on all the merits of the case. So, when thinking about the process of a matter needing to be appealed all the way to the Constitutional Court, one needs to have regard for the amount of time that this takes. We know that in Pretoria the rolls are very full because it is the busiest court in the country. So you know and I know that on a good day, an application on the opposed roll is somewhere between 5 months to a year to get, depending on the roll. An application for leave to appeal is a slightly more automatic matter, which takes a couple of months to be heard by the same judge that adjudicated and delivered judgment on the matter. Then should that be successful, then the appeal is lodged, and that takes another good few months to get heard. So you're looking at about 2 years, a year and a half to 2 years for that matter, for that process. If the matter is to continue to the Supreme Court of Appeal, at that point, it's about 2 months of pleadings for the application for leave to appeal, then another 6 weeks for the court to give you an answer as to whether or not they will hear the appeal. They hear the appeal, you'll probably be heard, including pleadings, another 6 months or so. Then you'll wait for a judgment, which is another 3 months at tops for the Supreme Court of Appeal. Then the matter, should you still be dissatisfied, or if the other party would like to cross appeal, will be taken to the Constitutional Court. There, as I said, a full application is made. From application for leave to appeal to the entire merits of the appeal are couched in one solid pleading. The other party will then be given the opportunity to respond in their answering affidavit, and a replying affidavit is issued, as is the normal course for all applications. And then the court will issue directions and heads of argument. So from start to finish, from your first notice of motion to the matter being heard in the Constitutional Court, can be upwards of 4 years. When conceptualizing a matter and thinking about the outcome, it's important to notify your client that this may take this long, and whether or not they have the emotional and financial fortitude to take a matter to its very final conclusion, or be dragged to have the matter taken to its final conclusion, is something that needs to be considered. Because this can be very, very expensive litigation, even if all of the legal team is charging at a minimal rate.